Welcome everyone to our webinar on employment essentials for tech businesses. My name is Ruby Hollinshead. I'm a Senior Associate in LegalVision's employment team. Just before we begin, just a couple of housekeeping items. You will receive a recording of the slides in your email after the webinar. You can submit your questions along the way in the Q&A box, and we'll get to answering those at the end. And then lastly, if you can just please complete the feedback survey after the webinar, it'd be much appreciated. So for the next 48 hours, you will be eligible for a free consultation with LegalVision to discuss how we can help your business. You just need to provide your contact details in the survey at the end of this webinar. So today, per the agenda, what we'll be discussing is the difference between employees, contractors, and their entitlements. We'll be looking at protecting your intellectual property and confidential information. We'll be looking at deterring employees from joining or starting competing businesses, and this is through Restraints of Trade. And then lastly, we'll be looking at some minimum entitlements, some remuneration options, including ESOPS and alternative policies. And then at the very end, we'll get to questions, provided we have a bit of time. So there should be soon a poll question showing up on your screen. If you can just answer that question, essentially what you consider to be your biggest challenge when managing employment in a tech business. I'll just give you a moment to answer that. So those sort of answers are really helpful for us. And if there's anything that pops up in terms of a trend, I will kind of get to that hopefully throughout the webinar. Okay, so we'll just start with the first topic. As I said, a really, really popular one this year, employees versus contractors. A lot of litigation around this point, as you may have seen in the media with the Uber case and things like that, that around the correct categorizing of whether somebody is an employee or a contractor. So as a business owner, it's really important you get these right, and these obligations to workers are vital sort of for maintaining that compliance with New Zealand employment laws. There is a very big distinction between employees and contractors, and essentially misclassifying a worker can result in some quite serious financial and legal consequences. This usually involves PAYE deductions, KiwiSaver contributions, ACC levies, and compliance with minimum employment standards. So understanding this distinction is very important, and we'll just have a look now at some of those key differences as you can see on the slide. This is the key differences between workplace employees. Interestingly enough, the last part there, the poll question, the most popular sort of challenge appears to be the hiring and retaining of top talent. So that's quite relevant. We've got a bit of that at the end of the webinar around some alternatives to sort of salary there. So we'll touch on that at the end. Sorry, jumping back to the slide. So working hours is the first key difference. So employees typically have set hours. They're determined by the employer. Contractors, on the other hand, have the freedom to decide their hours and essentially can do what they work when they want to, so long as they meet the agreed deadlines. Secondly, control over work. So probably relatively obvious, but employers with employees have control over their employees. Contractors, however, have that autonomy over their tasks. Thirdly, commercial and financial risks. So employees do not bear that financial or commercial risk related to their work. This actually lies with the employer, whereas contractors, they're essentially a business themselves. They are responsible for managing their liabilities and rectifying any defects in their work. It's common as well, they should have their own insurance. Then that fourth point, expectations of work. So employees have an ongoing expectation of work. They're going to turn up every day, hopefully. Contractors are generally engaged on specific tasks or projects, and they don't have an expectation of that continuing work. And payment there, so employees are paid regularly, weekly, fortnightly, salary or wages, whereas contractors are paid upon the completion of tasks through invoices most often. And then popping to that next slide, tools and equipment. So employers typically provide tools to their employees, laptops, phones, etc., whereas contractors are sort of more expected to supply their own tools and equipment as part of their independent operation. A common question we get is sort of sometimes some confusion around KiwiSaver. So employers must contribute to their eligible employees' KiwiSaver. However, contractors manage their own KiwiSaver and retirement savings. Same goes for tax. So employers deduct PAYE for their employees, whereas contractors are responsible for filing and paying their own taxes, including that GST if it's applicable. And then just turning to leave entitlements. So again, another common question. Employees are entitled to that statutory leave, so annual leave, sick leave, etc. Whereas contractors do not have these entitlements, and they must factor that essentially into their business operations when they set their sort of rate. And then lastly, the right to delegate tasks. So employees are usually responsible for carrying out their duties. They're not going to go and subcontract that to somebody else to do it, whereas it can be common for contractors to be able to do that. However, it does really depend what you put in your agreement. Sometimes, companies prefer to restrict the contractor to not being able to subcontract and just carrying out the work themselves. So when it comes to protecting your business, look, the distinction is really, really important, and it's assessed through several factors. And practically, there are a lot of contractors operating as employees and vice versa. However, you do want to be aware of it because at the end of the day, if a claim is made, what the court looks at is case law and the Employment Relations Act. And what they look to is the real nature of the relationship. So while you may have an agreement that says one thing, the court's going to look at a multifaceted approach around what actually was the true nature of that relationship. So and that goes to those factors I was just speaking about, what the hours were, the control you had over the employee, that type of thing. So just for some practical tips there to protect your business, really important that you outline the nature of the working relationship in the agreement, whether that's employment or a contracting arrangement. Regularly review those agreements. So circumstances evolve. Somebody may start off as a contractor. They may slowly start to get integrated in the business. Next thing, if a couple of years go by, you've not reviewed the agreement, and essentially it looks like they're more of an employee, at which time you want to consider whether you need to update that agreement and actually make sure the right relationship is in place. And then lastly, just understanding those risks. As I said, the misclassification will come if the contractor raised a claim that they were in fact an employee. That's when, if that claim was found to be successful, that you could be up for some quite substantial liabilities there. So always important just to seek advice from the outset. If you've got somebody not coming on, you're not too sure which is the right fit, it's best to sort of seek some advice to make sure you're getting the right contract for the right person. Okay, just turning now to some more contractual terms. So confidential information. This is a key priority for tech businesses. It's confidential information is really often the cornerstone of a tech business's competitive edge. This includes trade secrets, client databases, and other sensitive information. And that essentially, if it's disclosed, could harm your business reputation, your competitiveness, or your financial standing. So essentially, what is confidential information? It can be broadly defined as information that is not generally known and is subject to efforts to keep it private. So in New Zealand, there is information protected by law, trade secrets, and sensitive data, and the rest comes under the Privacy Act and other case law. There's also information that can be contractually defined information. So this is information identified as confidential in an employment or contractor agreement in this case. So that's business plans, strategies, proprietary software, company policies, manuals, and things like that. So you can define what you believe to be confidential information in the employment or contractor agreement. Just touching on those exclusions. So obviously not everything is confidential information, and it doesn't include information already in the public domain. It doesn't include information that the employer authorizes the employee to disclose, information disclosed as part of the employee's duties, obviously within reasonable boundaries there, information shared with professional advisors, example, lawyers, subject to confidentiality, and then information required to be legally disclosed. So that would be often during court proceedings. So why is this important for tech businesses? So tech businesses often operate in a highly competitive and innovative market, and a failure to actually safeguard confidential information can lead to a loss of intellectual property and a competitive advantage. breaches of privacy law and associated penalties, and then damaging. It's very damaging to client trust and business reputation if that sort of information is gets out there. So it's particularly vital in the tech sector in the sense that there's lots of algorithms, trade secrets, and that forms part of a lot of your core assets. So in terms of key contractual terms for confidentiality, employment or contractor agreements are essential tools for defining what this is and enforcing confidentiality. So just looking at those terms on the slide, it's important to define what confidential information is. So specifying what it includes, should include digital assets, databases, and IP. You should set out the obligations of both parties so that both parties are aware of what their obligations are. You should set out the scope, so detail the scenarios under which the confidentiality obligations would apply, usually when the employment ends or during third-party collaborations. You should set out some remedies for a breach, This is particularly probably more useful in a contractor arrangement. So what happens if, confidentiality is breached? Is there damages, indemnities, and things like that? And that can provide a pretty significant basis for seeking compensation if a confidential information is misused. And then that post-employment obligation. So that's important. So defining what happens to confidential information at the end of the employment, usually, making sure that materials are returned, things are destructed if they're sensitive materials, covering all those points. So those all form part of what should essentially be key terms around confidentiality in an employment or contractor agreement. Obviously, the wording is going to depend on which one it is. And then some practical steps for protecting confidentiality. So just making sure you've got secure systems. You're the tech business. I imagine that that's something that you're very much clued up on, but using encryption, access controls, that kind of thing, and then policies. So making sure you've got robust sort of data protection policies and making sure that employees are trained on this and aware of what their obligations are. And then those exit protocols. So that's enforcing these when somebody leaves, making sure they deactivate systems, that you retrieve those company devices such as phones, laptops, etc., anything else that they have in their possession. And then so look, the benefit of it is just making sure that they're embedded into their agreements, and by doing this you can minimize risks and you make sure you're legally compliant and you can really protect what is your most valuable asset. Okay, turning to IP, so relatively similar, but again, really important to tech businesses, whether it's an innovative software, a proprietary algorithm, or some sort of original content, securing and protecting your IP is really essential to maintaining that competitive edge that you have. So obviously taking proactive steps from the outset, such as addressing IP in the employment agreements, can save yourself a few headaches down the line to ensure your business really has the right ability to thrive. So why should it be addressed in an employment agreement? So if your employees are creating or contributing to IP as part of their role, which majority are, it's important to make sure you have clear ownership over those creations. So including an IP provision in the employment agreement, it secures your rights and it avoids disputes are the sort of two main reasons why you'd have it in there. In terms of what should be included, so you just wanted to, again, similar to the confidentiality, define the IP, so spell out what it actually includes, software, list on the screen, software, inventions, creative works, designs, etc. An ownership statement, so including a very clear statement around the fact that any IP created by the employee as part of their job belongs to the employer. And this really eliminates the ambiguity about ownership and who owns that IP. And then thirdly, that assignment clause. So adding a provision where the employee formally assigns all rights to any IP they create while working for you, both now and in the future. And that can help to ensure that you hold the rights as the employer to that IP. And then that last point there is confidentiality. So requiring the employee to keep your IP confidential, both during and after they leave your employment. And then moral rights. It's something that comes up relatively often of the question of what are moral rights, but Essentially, moral rights fall into this sort of category, and moral rights basically protect the personal connection an individual has to their work. For example, being acknowledged as the creator of some sort of piece of work. So while these rights are less about ownership and they're a bit more about recognition, it's still important to address them if you can in the employment agreements. Can be in a contractor agreement as well, but you can ask employees essentially to waive those moral rights where it's legally possible, just to ensure that you have flexibility in how the IP is used. And then sort of why being proactive helps. Look, including IP terms and employment agreements is, a simple and smart way to avoid just potential future issues. It really gives you and the employee or contractor clarity around who owns what, and it just ensures your business is in a position to leverage that IP should it need to. But by getting this right from the get-go, so from the onboarding process, you can really protect those innovations from the very beginning. Okay, so sort of moving on now from the IP confidentiality terms and looking more at a bit more specifics here. So restraint of trade. So essentially, how can a restraint of trade really protect your business? So when employees leave your business, they are free to pursue new opportunities. And this can include working for a competitor or approaching, your clients or staff. So for tech businesses, this can be a real concern, especially if the departing employee has had access to that sensitive information or key relationships. So a restraint of trade clause in your employment agreements can protect your business by setting boundaries on what that former employee can do for a specific time and within a specific area. So there's lots of different types of restraints. Generally, you would look to include either all of them or some of them, depending on what's reasonable within your business. But look, non-competition is super popular. That prevents the employee from working for a competitor or starting a competing business for a set period of time once they leave employment. Or during employment, it can be both. And then non-solicitations, that just stops the former employee from approaching your existing clients. There is also non-solicitations that prohibits the former employee from encouraging your team members or contractors to leave your business and work for them. And there's an additional one that's not actually on the screen there, but it's called a non-dealing, and that sometimes comes up as well. And that's actually even a restraint that goes even further and prohibits a former employee from providing products or services to a former customer or client, even if they had no active solicitation. So that's a very wide restraint, but essentially another potential one that you can include. Okay, so restraints in New Zealand often use a cascading structure to make them more flexible. As you can see on the slide there, restraint period options, 12 months, 6 months, 3 months, those are sort of the options around what's likely to be reasonable in terms of a length of period that the restraint applies for. And then restraint area. So New Zealand, Auckland, Central Auckland, those are just examples of a sort of tiered approach to, obviously, one's more restrictive than the other. Look, the court will generally find that a 12-month restriction across all of New Zealand is likely to be unreasonable. So you do want to consider shorter periods or smaller areas, and that's more likely to be enforceable in terms of if it's challenged to see if it's reasonable. So being flexible essentially increases the likelihood of the restraint being upheld. And just a sort of practical note there, so with restraints, they are essentially a deterrence in a lot of circumstances. And it's actually up to you to prove that it's reasonable if it's challenged. So if an employee leaves, they then challenge the fact that they've got a restraint of trade. It's up to you to prove it's reasonable. So you could include a 12-month New Zealand, but you need to prove why that's in there. So sometimes getting it right from the outset or having a bit more reasonable from the outset can save that sort of onus at the very end if it is challenged. Otherwise, it can act just as a deterrent. Some employers choose to not enforce it. They just go, okay, we're going to leave it. It was more of a deterrence to hope that didn't happen. Ideally, it is something that's enforceable if you need to, because as I said earlier, you're protecting that confidentiality, that IP, those relationships you've worked up, that employees worked up within your business. So just some key considerations going to that enforceability point. Look, they're viewed skeptically in New Zealand because they can just limit that person's ability to work, and saying that, as I said, we tend to suggest them as a deterrence, but they can be enforceable. And to make them enforceable or help show that they're enforceable, there needs to be a legitimate business interest at stake. So, including protecting that confidential information, as I said, for example, it must be reasonable. So that's the duration and the area. And then if the restraint is too broad or excessive, it may be deemed unenforceable. And at that point, sometimes the courts can actually amend it to make it enforceable. For example, if you had New Zealand, they may say, okay, no, it's more so that this region would be more appropriate. So they can do that, but it's just something to keep in mind that getting that right from the outset is quite helpful. And again, just that one size fits all restraint approach doesn't really work. So having the same restraint for somebody who's a senior manager as somebody who's, possibly new to the role or graduate, maybe not appropriate. You want to think about what they have access to, tailor it to their position, and maybe also look at periodically reviewing these restraints just to make sure they're still relevant and fair. So yeah, that's some key points there. And then last point, so draft them with care, as I said, make sure you're checking in and actually making sure it's right for that position. It's not just a one size fits all. Communicate, so remind those departing employees, that's really important. So when they leave, just reminding them, hey, you're subject to restraint of trade in your agreement. You can also remind them of other things in their agreement at the same time, confidentiality, that kind of thing. And then lastly, as always, if you're in trouble and need some help and you want to have a chat around what's appropriate, would just be seek legal advice from the outset and make sure that your clauses are actually watertight so that they're enforceable and align with what the current case law is sort of saying. So why does this all matter? So for tech businesses, look, confidential information, trade secrets, and client relationships are crucial. So having a well-drafted restraint clause can be the difference between essentially safeguarding your competitive edge or potentially losing it to a former employee. Okay. So turning now just to minimum entitlements. What are these? So these are things that, assuming you're an employer in New Zealand, it's essential to know and make sure you're meeting these. I won't go into too much detail. I know you can sort of see them on the screen, but we'll just sort of touch on these quickly, and I'll sort of look at some more sort of practical tips for you throughout the way. So obviously it's very important to have an employment agreement. This can be collective or individual, and it should outline the terms of their agreement. And just a practical tip there, completely on a side note, is that within your employment agreement, it's very common to have the workplace and where they work. And I know in the tech industry and a lot of businesses, it's common for employees to work remotely or work from home. And we see a lot of agreements where that's been recorded as the workplace, for example, work remotely or from home. So many businesses, and I'm not too sure whether it's as a result of post-COVID or just a sort of change in sort of mindset, is that they're requiring a lot of employees to come back to work. And a really common question is, okay, I've got a staff member that's at home working remotely and I want them to come back in. And then it's, can I force them back into the office? Look, the answer to that question will really depend on what you put in the agreement in the first place, and most specifically, what the location of work or workplace is within that agreement. So for example, if your agreement says the workplace is your office address or the office or whatever it needs to be, then it's much more likely that you can then rely on that to say that's your workplace. We require you to be at your workplace, that kind of thing. And you can enforce those terms of the agreement. So that's something really important. Just keep in mind when you are putting in the workplace around thinking about future-proofing. If it's completely remote role, then completely fine, or you can do a hybrid. Another practical tip is to think about if they are going to work from the workplace, you could always do a policy around working remotely. That way you can amend, change, that kind of thing with your policy. But not to be confused with the fact that also they can apply, employees can make formal applications, under the Employment Relations Act if they wish to work flexibly, and then you have sort of strict restraints around responding to that and considering those requests, but just more of a general point we're noticing. So yeah, minimum wage, hours of work, that kind of thing, that's all important. Minimum wage is currently $23.15. Annual leave, employees are entitled to that. Public holidays, sick leave, parental leave, bereavement leave, making sure you've got clauses around this in your agreement, health and safety. So making sure you stick to all of those entitlements that are on the screen, it's really important. If you don't, you do risk fines. and penalties. So now turning to our last sort of section, and this will be sort of relevant to those who answered on the poll that retaining staff can be quite difficult. This can sort of be looked at in two lights. So it can be a sort of a cash flow sort of alternative. So obviously sometimes techs are startups, there can be cash flow issues at the beginning or at any time, to be honest. And then the other point to look at it is helping to retain staff. So just some sort of options here on the screen as alternatives perhaps you could consider to just a traditional salary or wage. So firstly, that equity-based compensation, there's a few different options there. And it can look really incentivize staff. So especially those higher kind of demand roles, you could look at these options. So sweat equity. So this essentially offers employees and contractors potentially equity stakes in the business in exchange for their work. So this is quite effective in early startup stages with limited cash flow, but it can help align, your goals with the person's goals, and it can motivate them to contribute to its growth. It's really important to document this though, and document the terms to avoid future disputes. So for example, you need to specify the amount of equity available to be earned, what that person needs to do to earn the equity, and whether the equity will be issued upfront or subject to vesting or as a call option. So a few points to think about there. An ESOP, a very common one. So you can grant this to employees, and this is options to purchase the shares in the company at a set price at a future point in time. This can align with employees' incentives, company success, etc. And then profit sharing arrangements are offering employees a share of the company's profits as bonuses. That can work well as the business grows, and it can help sort of motivate employees to really aim for results there. And then another one, I've sort of touched on this already, but flexible working, remote working, very, very common as an incentive. Lots of people, and professionals really value that ability to work from home, work from anywhere. Just noting what I raised earlier around making sure you're aware of the risk of having that as a term of the agreement. And the benefits of doing so or not so. And then flexible hours. So offering autonomy around work hours is another way that permanent employees can, perhaps want to stay in a business longer because they're really guaranteed that flexible work. Another one is those extra leave entitlements. So maybe looking at unlimited or additional paid leave. So, maybe example, adding another week or two as a annual leave entitlement above and beyond the statutory minimum, birthday leave, volunteer days, and things like that, and sabbaticals for long-term sort of employees. And then those health and wellbeing benefits, gym memberships, and health insurance subsidy, or mental health supports, offering access to professional, mental health services. And then professional development opportunities, so training budgets, offering funding for courses and things like that. Another one is sort of work equipment upgrades, so making sure, you're providing them with high quality tools, laptops, tech allowances, another one as an idea. That recognition and rewards, so that can be really good if throughout the year doing little rewards to employees, say a small gift voucher or something like that, as a sort of incentive. And then a mission-driven culture, so just making sure you've got a culture that's fostering that sort of growth, collaboration where employees feel valued. And then so why these work, look, they can demonstrate your creativity and your flexibility within the workplace. You can build that loyalty beyond a paycheck, so not just what their salary says, and you really build that strong culture. Okay, well, I've just sort of got to the end of that, and I want to make sure we've got time for questions. So that will conclude the main part of our webinar. You can download our publication, which you may find helpful. It's the How to Hire and Inspire guide, and you can just scan that QR code or find it in our resources. And then upcoming events, so we've got another event on the 25th of February next year, and this will be advertised later in the week, but it's an employment essentials for startups. And then I am going to answer questions shortly, so just make sure you do put those in if you have any. We do have a few pre-submitted questions that I can get to that have come in, but essentially we'll just take a minute to tell you about LegalVision's membership. So by becoming a LegalVision member, your business gets unlimited access to our full team of 100+ specialist lawyers for all of your business as usual legal needs. So it's essentially like having your own in-house counsel for a fraction of the cost. So our team can assist you with unlimited document drafting and reviewing of business contracts, unlimited legal advice consultations, and unlimited domestic trademark registration and much more. So as a LegalVision member, you don't worry about the cost of lawyers ever again. So you can think of having your own in-house counsel or take care of all your business as usual legal work, and you can focus on running your business. And if you are in-house counsel, we also offer dedicated service to manage your high volume business as usual legal tasks. So to learn more about how membership or desk extension can help you, you can request a free consultation when the survey appears at the end of this webinar. Okay, and we've got some time for questions, so we'll just take a look at those pre-submitted ones. And as I said, just feel free to upload any on the way. All right, the first question was clarity around engaging contractors on a regular part-time basis, i.e. are they contractors or casual employees? So the distinction between contractors and employees, including casual employees, is important, and they're very different. So the key factors to consider, look, are the nature of the relationship. Does the worker have that genuine independence, or are they integrated into your business? Are they coming into work? Are they wearing uniform? Do they have hours they need to be in the office or doing work? How much control do you have over them? When, how, where? Where's the work done? Employees more so are going to have control. Are they going to come to a site or a workplace to help, to carry out the work? And then what is the real intention of the party? So what actually are they wanting? Is the expectation that they're an employee, or are they very clear they're a contractor? And then again, economic reality. So is the worker in business for themselves, or are they dependent on the company? So those are some factors to think about. But essentially, if they're working on a part-time basis, and that's sort of what the question said, this might suggest an employment relationship rather than a contracting one, because in a contracting arrangement, whilst they may work ad hoc, it wouldn't be essentially part-time, because part-time tends to lead to the fact that you've got set hours, and they might be, say, for example, 15 to 20 hours per week. However, it needs to be assessed on its own merit. So we'll be having a look at that and seeing what parts of that sort of test I've just said to you apply, and that can help you determine which one's which. And just another point there, so obviously casual is quite different to permanent. You wouldn't get a casual part-time, because casual employees have no ongoing expectation of work. Essentially, each day they come into work, or each shift they come into work, is the end of their employment. If they get offered the next day or the next week, then that's not guaranteed, but it's only a possibility. So that's just sort of to answer that question around engaging contractors on a regular part-time basis or casual employees. And there's one that came in sort of in terms of anti-slavery and anti-bondage laws here in New Zealand and Australia. If an NZ or Australian company has a sister co in another country and they practice slavery or bondage type entrapment in that country, can the New Zealand/Oz co be held accountable? I will preface this by saying I think that you will want to get some specific advice around the situation, but look, from what I understand, I'm not an Australian expert, but Australia have modern slavery laws, and if they're applicable, it would essentially probably be a problem if you knew there was modern slavery happening. But if it just happens generally, without your knowledge, that could potentially not be as much of an issue. But you do need to take steps to identify, mitigate, and reduce risk of modern slavery. So I would suggest speaking to a New Zealand and Australian qualified lawyer there to just check that you're making sure you're meeting all your obligations there. And then there's a few other questions coming in. I'll get to the other ones shortly. So the extras, sabbatical, free childcare, free staff cafe have tax implications. So a great question for your accountant. There may be, look, there'll be ways that I imagine, I'm not an accountant, but there'll be ways that, that could be classified. It will be probably different. So I think it would, sorry, and when I say different, I mean different tax implications to what you normally would have. I think just check with your accountant on that. Second question is, what about employing/contracting Aussies or UK? Are there NZ legal issues? So that's a really good question. it's quite common to be a New Zealand-based company and you want to contract to somebody that's overseas. What's really key is what is the governing law in that contracting agreement. So if it's you as a company drafting the agreement and you're based in New Zealand, it's more than likely that you're going to say that New Zealand laws apply. And on that basis, that is essentially the law that applies. A common one is that we get employees or contractors living or working in Australia or New Zealand, and the company is either in Australia or in New Zealand, and you're, on either one of those parts of the world. That is when it's an IRD question around, are you actually a company and should you be paying tax in that company? So it's something you do want to check from the outset. But to answer that question specifically, depends on what the governing law is, because if you're signing an agreement that says this is subject to Australian law, then essentially if there's a claim by the contractor that they're an employee, it's very likely it could go to that court. So you just want to make sure check what your governing law is. And I'll just get to those other questions that were pre-submitted. Yeah, so one of the questions was just general employment legislation updates. Look, these come out all the time. It's great to keep an eye on them, but I'll just sort of summarize what the key ones have been this year. So earlier this year, 90-day trials became available for everybody. Previously, they were only available to businesses with fewer than 20 employees. So that's just another one to keep in mind. Very recently, the Workplace Relations and Safety Minister, Brooke Van Velden, just announced that there's going to be some changes to the Employment Relations Act next year that will enable employers to ensure they have the right fit for their high impact leadership and specialist roles. And essentially what that means is they're going to introduce an income threshold of $180,000 per annum for unjustified dismissal personal grievances. So it basically means that employees earning above that will be unable to raise an unjustified dismissal claim. Lots of details to come around what this is going to include, but that's just something to keep in mind. It will be introduced next year as the aim by the government. Another one that came up, this is more so 2023, but it's still something I'm seeing a lot, is the extension for time to raise a personal grievance due to sexual harassment. Now that has increased so there's 90 days to raise a personal grievance in New Zealand. That has now been updated for sexual harassment personal grievances only to 12 months. So your employment agreement should be saying that in there, that the employee has that time. And then actually today, a new update has come out. I think it was yesterday. A new update came out again from Minister Brooke Van Velden. And this is a new update that's going to come into sort of force next year with the Act as well. And there'll be new updates in the new year regarding, poor employee behaviour. And that basically is going to contribute to how they can seek remedies for personal grievances and things like that. So keep in mind that early next year, there'll be a fair few changes to possibly, well, it may not be early, but next year, there'll be a fair few changes to the Act potentially. Okay, it doesn't look like there's too many other questions coming in. I'll just give you another sort of few minutes or few seconds to put any in if you do have any. I'll just double check I've answered all of your pre-submitted questions that I can. I think that's all of them. Okay, well, it doesn't look like there's anything else. So that's sort of all for today. Sorry if you did have a question, you didn't get it answered, as I said, and you didn't have time. Just make sure you do submit your details for that consult, and we can assist with answering those questions. And then again, you can submit your details just to learn about how our membership can help you. So while this is a free webinar, we really value your feedback. I'd love if you could leave a review, and I really appreciate your time. So there'll be a 30-second survey at the end. Thank you very much for joining us. Have a great rest of your day.